Good afternoon, everyone. We're going to be doing a presentation on H-1B professionals, discussing the impact of executive action in helping with the H-1B lottery and covering some of the basics of the H-1B application process, as well as I will probably digress into a little bit of the history. For those of you who have Google Hangouts, you may post questions on this, and we'll try and get to the questions. We'll also try and save some time at the end for any questions that people want to send in. Also, as I will announce at the end of the presentation, we have a package, several different packages of information that if you decide you want to put this package together yourself, that will help you put together an H-1B package. We're going to hang out another minute to give everyone time to log in, and then we will start. Thank you. Hi, this is just to let people know that we will be proceeding shortly with the H-1B webinar on how executive action may or may not help this year's H-1B lottery. We're going to wait a few more minutes to allow other folks to log in. So if you will be patient, we will be right with you. Thank you. Always. Okay, good afternoon. This is Roy Watson, and welcome to the H-1B webinar. This is the second in a series of 3 parts that are discussing the impact of President Obama's presentation and announcements on November 20th. This particular presentation has been extended several times because of snow. Up here in Boston, we've had just a little bit of snow, so we were forced to continue it, and we decided to move to the webinar format because of the continued difficulty that people may have in getting to our location. However, our third and final presentation is as yet unscheduled. Again, we were forced to continue it, but we're hoping to have Representative Michael Capuano, who is a member of U.S. Congress, to appear, and he will talk about the broader implications of what President Obama discussed. The issues that President Obama discussed are many. The discussions that we've already had on it focus on immigrant visa issues. The timing of this presentation is dictated by the rapidly approaching April 1st deadline for filing. So let's look. What is it about the H-1B visa? Well, it is probably our most popular work visa. It applies across the board in terms of jobs, but it does have certain requirements. And unfortunately, in spite of President Obama's announced willingness to facilitate the entry into the United States of highly skilled, highly educated, highly qualified individuals to improve the United States, improve our economy, increase jobs, all of them specifically announced goals of the president. Unfortunately, what we see is an agency that is not necessarily taking its direction from the president. What I'm specifically referring to is, for years now, we have seen Citizenship and Immigration Services, and before that, the Immigration and Naturalization Service, has attempted to do something that we in law call legislation through decision making. What we mean by that is that the government agency attempts to change the law by issuing decisions irrespective of whether or not those decisions follow the strict law. Another way of accomplishing this is for them to strictly and rigidly interpret the law. And that, again, unfortunately, is what we are seeing with the H-1B lottery. Let me try and cover that. So the H-1B is the only temporary work visa, or the H visa is the only temporary work visa with a numerical cap or limit. This was done in 1990. It was strictly political in its actions. It was in response to a complaint by a constituent group saying that foreign nationals were taking jobs from the members, and the then chairman of the House Judiciary Subcommittee, a gentleman by the name of Bruce Morrison, enacted the cap. We were assured that the number on the cap was so high that we would never hit it. Of course, as history shows, we've been hitting the cap almost without exception since it was implemented. The current cap is 65,000. However, certain visas, 6,800 visas, are set aside for Chile and Singapore as a result of a separate treaty. Those unused numbers are then added back into the cap the following year, so it's difficult for us to come up with an exact number, but it's a safe estimate that there are between 60 and some number less than 65,000 H-1B visas available every year. Following the regression back to the original cap number, we were able to lobby for an additional 20,000 visas that are set aside for individuals who earned a master's degree or higher from an accredited nonprofit public institution. These master's cap visas have been very, very helpful for people who have earned master's degrees or higher here in the United States. Sadly, we have seen a problem, and we are alerted to a problem this year where the Immigration Service, CIS, is going to crack down on that definition and begin restricting who can qualify. The definition is found in section 101A that talks about public, nonprofit institutions, and the Immigration Service has indicated that they will apply a strict definition. So the problem arises that you have a master's degree, you think you're fine. However, if you went to a school that was a private institution, and if it is not a nonprofit institution, then your master's degree will not count. Now, the problem there is that the number of applications we expect to receive should fill up all available visas on or about April 1st. Typically, if you enter the master's degree lottery and those visas are given away and you have not qualified for one of them, you will be automatically entered in the general lottery. However, if we see CIS strictly examining master's degree applications for proof that the schools are public or private nonprofit, and you do not qualify, then by the time you find that out, you'll be too late to be included in the general visa lottery. Let's talk for a moment about the general visa lottery. Again, there are some number between 60 and 65,000 visas available each year for the H-1B. The Immigration Service in the past used to use a first in, first served, or first come, first served allocation system. The problem is, several years ago, on April 1st, they received something close to about 160,000 applications for only 60,000 visas. This application process that was only done on April 1st essentially shut down the town of St. Albans, Vermont, up in Vermont, which is the processing center for H-1B visas. The Immigration Service has now changed that system, not to make it easier for people applying for the visa, but to make it easier for them and the town where they reside. And they have allowed now a 1-week filing window. That filing window starts on April 1st. So that would be for this year, that would be on Wednesday, and it would extend until the following Tuesday. If they receive more applications than the number of visas available, then they will set up a random lottery. And all applications will be processed based on the random lottery system. If you qualify for a master's degree visa, the 20,000 master's degree visas, and if all of those visas are used up and you are not selected, you will then be automatically entered in the general visa lottery, the general H-1B visa lottery. Again, the problem and concern is there is zero tolerance for errors, because if for any reason your application is returned, then by the time you correct the problem and send it back, that 1 week window will have closed and you will be excluded until the following year. So it's very, very, very important that you check and double check the application to make sure that all of the signatures are in place, to make sure that the right amount for each one of the applications, and that you have all of your supporting documents. With respect to the supporting documents, the government will generally issue something called an RFE, a request for evidence. So if the problem is a missing or possibly defective document, then you will have a chance to recover. You will still be in line, you will still be being processed, and you'll have an opportunity to respond and submit the requested documentation. But if the flaw is a procedural form, such as an unsigned check or a form that you missed a signature on, that form will be returned to you and it will then be too late to resubmit. So let's move over to the statements that were made by President Obama on November 20th. On November 20th, President Obama addressed the nation and he issued an executive memo. It was not an executive order, it was an executive memo. And although the issues covered on that evening covered a wide range of issues, let's focus on the employment issues in general and the H-1B employment issues in particular. One of the things that the president did talk about that evening was the possibility of extending optional practical training. Optional practical training is currently available to anyone who completes a degree granting program. Optional practical training is limited to 12 months. This particular program is actually administered by ICE, Immigration and Customs Enforcement, one of the three immigration branches under the Department of Homeland Security. What they did a number of years ago was they expanded optional practical training to allow it to be extended by an additional 17 months, thus authorizing a total of 29 months under optional practical training. However, in order to get the extension, they imposed certain restrictions. So in order for you to extend optional practical training beyond your 12 months, first of all, you have to have what is known as a STEM degree. STEM stands for science, technology, engineering, or math. Number one, Number two, you must be employed in a STEM field. And number three, the employer must be registered under a program called E-Verify, or electronic verification, that verifies the validity of a Social Security number. Now, right now, the two time periods for OPT, the 12 months and the additional 17 months, should, for most applicants, provide a window for you to apply not once, but twice under your for an H-1B under optional practical training. The problem, if we look at last year, the problem that we see is that your chances across the board, your chances of getting selected for an H-1B visa are roughly 50%. It is slightly higher if you have a master's degree and slightly lower if you have a bachelor's degree. But that means that 1 out of 2 applicants last year never even got considered. It's not that they were denied, they were not even considered. So if you have 2 chances to obtain an H-1B visa, then you should take both of those chances. You should apply as early as you can and as often as you can. In some cases, we have seen people delay filing for an H-1B visa initially on the theory that they would apply the following year and simply continue working on their OPT. If this year is a reflection of last year, then 1 out of 2 of those people will never get considered. This year, the projection is the reason we had so many applications last year was because there was an improvement in the economy. All indications suggest that the economy has improved even more this year than it was last year, suggesting that we are going to get an even larger number of applications for H-1B visas this year than we got last year. So that would, unless there is some magical change in numbers, that would mean automatically that the odds of getting selected are even lower this year than they were last year. And they were pretty bad last year. Let me simply add that this is in the face of other countries, almost all of whom have passed special legislation to facilitate the entry of educated individuals into their workforce. All other countries, except the United States, recognize the benefit that this highly educated workforce brings to the table by not competing against, quote, US workers, but rather expanding all jobs across the board and making more available for everyone to share in. In terms of what President Obama may or may not do, it is absolutely within his scope of authority to extend OPT, optional practical training. And if that happens, then there may be an opportunity to remain here for even a third round of applications for H-1Bs. A number of people have been precluded from applying for the 17-month second extension because their degrees are not so-called STEM degrees. An example of that would be a master's in business administration. A master's in business administration is not considered generally is not considered science, technology, engineering, or math. Although, yes, there are certain MBA degrees that are specialized enough to qualify. The general MBA degree does not qualify. One of the things that President Obama talked about in his request was to solicit from all of the related agencies guidance on how to improve this system. One of the things that was discussed was to allow individuals who have a STEM undergraduate degree to qualify if their master's degree was not a STEM degree. So if you have a degree in electrical engineering as a undergraduate or a bachelor's, and you subsequently obtain a master's in business administration, the proposal would allow you to file and qualify for that second 17-month OPT OPT STEM extension. Another thing that was discussed was allowing H-4s who are spouse independent of H-1B visa holders, allowing them to work in similar related categories, which would be the L1 intracompany transferee visa and the E1, E2 treaty trader or treaty investor visas. Spouses of approved visa holders may work. Again, when the H-1B definitions were changed, they specifically restricted work authorization and did not allow work authorization for spouses. There has been a proposal, it was made in May of last year, in May of 2014, and that proposal would call for authorization of H-4 visa holders to work. Another optimistic request that the administration is exploring is to dramatically increase the number of H-1B visas. Now, there was a proposal under the Senate Bill 744. Under Senate Bill 744, the so-called Comprehensive Immigration Reform Act, there was a proposal to expand the number of H-1B visas. Subsequently, several senators have proposed yet a new bill that would dramatically increase the number of H-1B visas. And if that happens, then this would or should alleviate the problem of not having enough visas. It was not so long ago that we had visas, H-1B visas, year-round, and that anytime an employer wanted to hire somebody for an H-1B visa, they could. No longer. All right. The other issue that was discussed by the president is so-called parole in place, and that would allow people to pre-register for adjustment meaning changing your status in the United States from whatever it is to green card or immigrant status. There is a proposal that the president is exploring that would allow the administration to grant parole to individuals who can demonstrate that they have the necessary skills to create technology jobs. The other final item listed on the slide that talks about recapturing green card numbers is something that President Obama also talked about, although it does apply more in the field of immigrant visas. And the recapturing of green card numbers reflects the frustration of not using up all available numbers when there are backlogs that go back for years and years. So there are proposals that would include that. On November 21st, the government issued a memo, the executive office issued a memo, the president's office issued a memo to the heads of all of the related agencies, which would include Department of Homeland Security, Department of Labor, etc., issued a request to all agencies to come up with a program to facilitate and improve employment immigration, streamlining our U.S. immigration system. The recommendations were to come within 120 days of the date of the memorandum. Now, the government is notorious for not adhering to their strict limits, but that would be 120 days from November 21st. So somewhere on or about the middle or end of March, we could expect to hear something. I can report that we have already seen activity by the government to solicit the thoughts and suggestions of the private bar. And a number of agencies and groups have responded to that to provide people with information regarding that. So here we go. So one of the proposals that we have is the Immigration Innovation Act of 2015. The Immigration Innovation Act of 2015 would actually move the cap from the 115,000 proposed by the Senate bill, Comprehensive Immigration Reform Bill, to up to 190,000 visas. The other proposal and the Immigration Innovation Act of 2015 is often called I-squared. So if you see discussions regarding I-squared, that's what they're talking about. I-squared also talks about removing the 20,000 cap for advanced degree holders. There have been a number of Republican senators who have argued that any foreign national who graduates with an advanced degree in STEM, science, technology, engineering, and math, any individual who graduates with an advanced STEM degree should automatically be granted green card status. Removing the 20,000 limit or cap for advanced degree holders would go a long way to helping improve that problem. Again, I-squared also requests the authorization for spouses to be authorized to work. One of the other things that it would do is it would recognize dual intent for foreign students. One of the sections of the Immigration Act, Section 214B, says that all individuals seeking to enter the United States are presumed to have an immigrant intent. What that means is if you stand at the border silently, technically the officer, the Customs and Immigration, Customs and Border Protection officer, is theoretically entitled, almost mandated, to refuse your admission, because the burden is on you to overcome that presumption that you're seeking a green card. Now, the problem back before they granted DS, or duration of status, we had a situation where every year students were given 1 year, and every year they had to reaffirm their intention to depart the United States at the end of that 1 year. Really, think about it. You just completed your 2nd year of a 4-year degree program, and you have to go in and say, oh yes, I'm expecting to leave the United States next year at the end of my junior year. That's one of the reasons we came up with duration of status. The other issue would be to recapture green card numbers. And these could be done in a number of ways. One of the most exciting proposals that we have seen, and this is in the immigrant area, not the non-immigrant area, but one of the most exciting proposals we have seen in the immigrant area would be to change the current system. The current system, if you apply for an employment-based visa, and just for the sake of discussion, you are married, you have a spouse and 2 children. If you apply for an employment-based immigrant visa, you will use up 4 of those visas, 1 for yourself, 1 for your spouse, and 1 each for your 2 non-working children. Under the proposal that we hope will pass, the government will only charge 1 employment-based visa for the 1 person who has been authorized under the employment-based visa program. This would have the equivalent, or the impact, or the effect of nearly tripling the number of immigrant visas available to be distributed. This would dramatically cut down the current backlogs that we have. So we can all only hope that this will come to pass. There are also proposals that would exempt EB1 and EB2 applicants from the green card cap. And finally, there are discussions of eliminating or certainly adjusting the annual per country limits that apply most harshly against citizens of India and the People's Republic of China. So sadly, we see no changes this year in the H-1B program, but we are optimistic that there is pending legislation. Everyone needs to be mindful of the upcoming April 1st deadline. Again, there is no room for error. You must make certain, if you're going to file this, that you file a flawless petition, because if it's returned to you by the time you get it back into the hands of the Immigration Service, it will be too late. And now is when you should begin preparing that. Again, if there are listeners who have Google Hangouts, you can submit questions, and we will be happy to answer those questions. Also, we have, and let me get to the last slide, we have a package of immigration-related resources, including H-1B checklists, etc., that we would be happy to send out to any of the listeners of this program. If you send an email to me, the email address being roy@watsonimmigrationusa.com, and just reference H-1B webinar in your title, then we'll be happy to send you the resource materials that we've assembled. So if there are any questions, we'll hang out. There's no audio questions that we can take, are they? It's only, I guess it's only, the questions are only available if you have Google Hangouts. So if you have Google Hangouts, we'll be happy to answer your questions. Also, if you wish, since there's a small enough audience, if people have questions and they wish to call in to the office, the telephone number for the office is 781-533-7700. And if you indicate that you were listening to the webinar and you have a question, but you did not have Google Hangouts, and you wanted to follow up with a question, we'll be happy to take those questions. Otherwise, I guess we'll end the webinar. And again, as a reminder, please look for our third and final program on the Obama legislation that will include U.S. House of Representatives Michael Capuano talking about this legislation. And thank you to everybody who tuned in and listened. Appreciate it.